Donald Trump files a motion to sever in the Georgia case. Remember, he's one of 19 co-defendants, and some of the co-defendants are federal officials. They're also trying to remove their case from the state level court, which is where Big Fanny is operating, and take it up to the federal level. And so we've got a bunch of stuff happening simultaneously. We're going to go through two of the main highlights here. Donald Trump's motion to sever himself at the state level from the other 19 co-defendants. So Trump is going to say, I don't want to be with Sidney Powell. She's the person who wants a speedy trial very quickly, and trial's coming up like in October. So Trump says, no, too fast for us. Also know Kenneth Chesebro and others are going to be moving that direction. And so Trump wants to sever from them at the state level in Big Fanny's Fulton County. So what the other point is that Mark Meadows, who's also a co-defendant in the same state case, is filed and has been battling this, a removal request to take his case out from the state level and bring it up to federal court, which would also, in a way, theoretically sever him from other co-defendants. So one is severance by removal, and we've got a bunch of different categories of co-defendants, because some people don't get to make that federal request because they weren't federal officials like Mark Meadows was. Of course, he was Trump's chief of staff. So you see, we've got some technical stuff to get to, but I think it's going to make a lot of sense when we see how it lays out. This is the filing by Donald Trump. Case, of course, state of Georgia versus Trump. This filed August 31st, Superior Court, Fulton County, Georgia. This is where Big Fanny lives. Judge is Scott McAfee. This is Trump. He says, this is my motion to sever my case from the co-defendants who demanded a statutory speedy trial. And previously here, we've seen that Big Fanny Willis, the biggest DA in Georgia, which is why she's Big Fanny, is somebody who does not want all of the same rights to apply now that this speedy trial has been invoked. He's saying that those people who requested a speedy trial now are waiving other rights about proper notice, about the evidence, and whether they can get that evidence in advance of trial or how quickly in advance of trial. And so this is becoming a little bit of a mess even for Big Fanny. So President Trump now moves to sever his case from those co-defendants who have demanded a speedy trial under Georgia law, Powell, Chesebro. They've got a scheduled court date coming up October 23rd, very, very soon. The underlying reasons and justification, says Trump, for the court to exercise its discretion here, judge, and grant the severance, meaning Trump gets separated from everybody else, are the following. Trump's lawyers say the substantial adverse procedural and substantive effects that President Trump would endure, as noted in the government's file, which is the notice of the speedy trial rights and the demand upon evidentiary and procedural rights in support. So this was the motion that we read previously that Big Fanny was submitting. She was asking the court to kind of scold the defendants. Oh, you want a speedy trial, don't you? Oh, well, I guess you're going to get what you asked for. And so if you have a speedy trial, then you don't get right to proper notice of the evidence against you. And we're all sitting here going, wait a minute, what? Like, from the defense perspective, that's the whole point of requesting a speedy trial, is to make the government have to adhere to their deadlines, have them fail. When they fail, the evidence is precluded and they can't use it. That's the whole point. So when Fanny was saying that, well, you can have a speedy trial, but all of those other things that we have to comply with are all waive them. It's like, wait a minute, what? No, they did not. So Trump is saying Fanny in that filing wants the court to advise Trump of all this. And Trump's saying, this is ridiculous. Like, we don't want any of this stuff. So please don't advise us. In other words, they say undersigned lead counsel, so Trump's lawyer, specially set trial in the Southern District of Florida before Judge Cannon on September 26 in U.S. versus Doherty. So this is not Trump's case, but the lawyer, so this lawyer who is called Stephen Sado, he's just notifying the court, hey, we've also got a conflict. Like, I'm due in trial on September 26 for a totally unrelated case. 3 defendants are going to trial, and the case is expected to last 2 to 3 weeks. So September 26, 2 to 3 weeks, going to bump him right into October 23rd. Undersigned counsel, the lawyer, says that I'm not going to have sufficient time to prepare Trump's case for trial by that date, which is the date that Chesebro requested the speedy trial. And the lawyer says, okay, look here, Your Honor, respectfully, let me be very respectful to you, requiring less than 2 months preparation time to defend a 98-page indictment, charging 19 defendants with 41 various charges, including a RICO conspiracy charge with 161 overt acts, solicitation of violation of oath by a public officer, officer, false statements in writing, forgery, influencing, computer crimes, conspiracy to defraud the state, and other offenses would violate President Trump's federal and state constitutional rights to a fair trial and due process of law. I'm just explaining that there's a lot going on here, Judge. And you can see this, 19 co-defendants. Obviously, this is kind of insane. The defense is highlighting, honestly, kind of how insane it is to go to a trial so quickly, right? The fact that Kenneth Chesebro and Sidney Powell are going to trial is the strategy, right? This is why they are doing it. They're saying, oh, all right, Big Fanny, she's so confident. All right, let's see if she can do it. Let's go to trial, baby. October 23rd. She's got 19 co-defendants, 41 charges, 161 over. Go ahead, do it. Let's go. And Trump's people are obviously saying, well, that's not going to be our strategy, right? We're not going to try that one. So we're going to ask for a long continuance. Please don't lump us into this same category. So they say, wherefore, President Trump respectfully requests that the court grant the requested severance. Respectfully submitted, Stephen Sado. And we'll see if that happens or not. And remember, this is only one portion of this entire conversation. This was the motion to advise the defendants of their speedy trial demand, saying that, you know, Your Honor, because they want a speedy trial, guess what? They have waived a bunch of stuff, waived the 10 days notice of discovery. So we don't really have to tell them about the evidence until we get, maybe until, I don't know when. I don't know if there's any limiting principle on it. You know, it's just like, we're just going to show you the day before trial. Guess who's showing up tomorrow? You waived your 10-day notice. Like, what? Kind of insane. So this is just one portion of the Trump severance, one portion of the possibility for the case to deviate off of its current trajectory. But the other component is the removal, which is Mark Meadows. And this was Trump's chief of staff, who now wants this case to leave Big Fanny's court and go to the federal district level. So he submitted this one, supplemental brief by Mark Meadows. And a lot of people are saying that this is just kind of cover for Trump. If Mark Meadows is successful here, Trump may do the same thing. And people on the left are flipped about this. Okay, we're going to come back shortly after we're done with some of this analysis and see exactly what Weissman is saying about this, because he's saying if this case gets removed, if it comes out of Big Fanny's courtroom, well, that's going to mean that it's in the federal system, and the federal system doesn't allow cameras in the courtroom. Oh man, they really want cameras in the courtroom on these cases because they think it's going to be very harmful to Trump. I personally would be thrilled to see it. I'd love to see Fanny out there and just see what she says, if she says anything, and watch the media just, you know, yes, queen, all her, all day long. Like, okay, let's see it, because I don't think that they're that competent. So I want to see it. Let's put it on display, and they can hem and haw about what a serious ordeal this was. And it's just text messages and meetings. It's like, all right. So here's Mark Meadows, who's going to be filing this thing and removing it up. Says that the court, Your Honor, this is Meadows' lawyers, the court has asked for a supplemental briefing on whether this is the following question. Heavy lifting. But they say here, a finding, this is the question the judge said. The judge said, hey, Big Fanny and Mark, I need an answer on this question. I need to know. If a finding that at least one, okay, so at least one, but maybe not all, of the overt acts that Big Fanny is alleging, if one of those overt acts, just one, if that happened under the color of Mark Meadows' office, so like if within his job description, would that be sufficient for federal removal? If one act alleged fall within Mark Meadows' job description, like was legal, or arguably legal, or arguably defensibly legal, right? Like you could say, I was a federal official and my defense is a federal defense. I was acting within the color of law. Can that justify the removal of the case from the state Big Fannies to the federal court? And this would have serious consequences because it would not be in Fulton County anymore. Now we'd have a jury pool that could expand out to the rest of Georgia. Now we've got a federal judge involved. That would be, appealable to the Court of Appeals for the federal circuit. We're playing at a different ballgame now, right? We're not dealing with the Big Fannies of Georgia. So they're freaked about that. They want their blue county and their jurors to just go and incriminate Trump. They want it to be like the Coliseum on display. They throw some gladiators in there. Everybody just munches them to bits. So if Trump removes it, they're going to be in trouble. So the answer, says Meadows, is yes. If one single act falls within Meadows' job description, yes, of course, Judge. That's what this removal is for. He says, Your Honor, removal is required if the, quote, prosecution relates to any act that occurred in the course of official duties. That's pretty clear, Your Honor. The statute, binding precedent, Hornbook law confirm that a prosecution is removable if any part relates to an act under color of federal office. Right, so this is kind of like a backhand. This is like a legal backhand. It's like, all right, listen here. All right, this is not even complicated. All right, the statute says it, the precedent says it, the case law, and the law that explain, the books that explain the law all say the same thing, that a prosecution is removable if any part of it, even one overt act, relates to an act that's within the job description. Removal is thus required, telling Your Honor, if at least one overt act charged as a connection or an association to even, quote, the outer perimeter of his line of duty. So if it's even like questionable, it's within the context. So Big Fanny's like totally out of bounds here. They say, here's, Your Honor, here's how simple it is. Here's the statutes. The text says two particular aspects of the text as written confirm this. Pretty simple. The federal officer removal statute refers to a civil action or criminal prosecution, which is the category we're in. It doesn't refer to different claims, counts, or theories, and it authorizes the removal, quoting now, against or directed to a federal officer, quote, for or relating to any act under color of law. Bolded, referenced U.S. Code 1442A. The statutory text itself, the law itself, thus shows that the case would be removable if some, but not all, of the charged conduct relates to Mr. Meadows' official duties. So this is like, think about it this way. Mark Meadows did one thing that was within his job description, and he did a bunch of other stuff that's not. Big Fanny charged him with all of them. So if even one of those was within the federal level, everything else goes as clear as day in the law. There's also case law. He says binding precedent. The Fulton County Fanny knows from recent experience, knows this. And this is great. Oh, this is great. All right. So the Fulton County even knows about this. Why? Because the Fulton County got the old legal backhand from the Court of Appeals when this thing came back on a denial during an appeal process. Here's the claim: that if one claim is cognizable, is present, if one claim is present, the entire action is removed, regardless of the relationship between the claim and the non-removable claims, okay? If one thing is within the job description, but other things are not, doesn't matter. The fact that one is, the whole thing goes. And how do we know this? Look at this case, Georgia versus Hines, coming out of the Northern District of Georgia, 2022. And this is where Big Fanny got remanded, denying remand of changes by Fulton County District Attorney against federal task force officers. The state argued that the officers could not be acting under the color of federal authority, much like the argument here. The Hines court rejected Fanny's argument, said it was irrelevant to whether they acted under the authority of federal authority, okay? So Fanny is being dishonest here. She's already lost this issue before. And specifically, Fulton County appealed it and the court dropped it back on her. Said, nope, can't do that. Sorry. But she's trying it again. That's dishonest, man. This federal judge, we'll see what he has to say about that. This proposition is binding precedent under Nadler. There, the 11th Circuit addressed the jurisdiction and immunity. It was a defamation case. Somebody sued a U.S. attorney who was a candidate for the judgeship. On immunity, the court concluded that under a state law standard, the arranging of a whistleblower with the FBI was not an official act, but that leaking the investigation was an official act, but that leaking to the press was not. Saying that removal, it makes clear the court must permit removal if any, not necessarily all, relate to the official duties. Many other federal courts agree. Look at these, all of these courts. Baker, here's one. Morgan, Sawyer, Mesa versus California. Another one. We have Hornbook Law. Also, this procedural book. Oh gosh, these law school books. Oh gosh, this is what our professors used to make us go get. Wright and Miller, Federal Practice and Procedure, Section 3726, which are these big books that explain the laws. Even if it says, lastly, it's Hornbook Law, it says when it explains this, authorizes removal, even if only one of the controversies, only one, if it involves a federal officer, signed by, written by Wright and Miller. All right, so the actual law explains it, the case law explains it, and the books that lawyers use to explain the law explains it. So Big Fanny should lose, Your Honor, as the state's framing of the case does not control removal. Removal is also required, writes Meadows' lawyers, even if the state has charged some acts beyond his official duties, because what controls here, this is it, is Meadows' articulation of his federal defense, not what the state says in their charges, right? The point of this law is to make sure that the states can't just act like little, ankle biters, just nipping away at federal officials, or much worse, like tactical coup organizers who are justifying weaponized criminal prosecutions against their political opponents. Not supposed to happen. And so we've got federal supremacy, and if these acts happen when they were within the conduct of their office, they should be immune. They should be able to remove this and deal with it at the federal level so that little peon partisan hack prosecutors can't just emerge and start their attacks. So if we make the law that's created to protect against that from happening, if we base it on what the prosecutors say, well, then that's kind of a dumb law, isn't it? Because the prosecutors are always going to say it's legitimate. So we instead, as a matter of policy, make it about the federal defense, because we're trying to protect the federal officials against this type of garbage. So they explain that. The state also cannot avoid removal by mixing charges of some removable and non-removable conduct. Like, that's nuts, right? You wouldn't be allowed to do that. All they would do is just defeat the removal by tacking on something that's unofficial, and they would be able to usurp the entire point of the law. So obviously that's illogical. Federal courts have also held that the state cannot evade removal by disclaiming any reliance on official acts. So Big Fanny can't say, well, we didn't rely on any official acts. The record here makes clear that Meadows, everything that he did related to his duties, to his official duties. So they say, Your Honor, pretty simple here. Under the black letter legal principles, Mr. Meadows is entitled to removal. And you can also just translate, a lot of this to Trump. You can interchange Trump in here for a lot of this. His unrebutted testimony establishes the broad scope of his official duties. He was assistant to the president and chief of staff. 3 categories. He provides the president close confidential advice, right? In other words, you could just say Trump is the president, right? Trump is if this applies to Meadows as a subordinate of the president, kind of applies to the president, no? He using his discretion to gather information, including from state and federal officials on a wide range of interests, federal interests, potential policies, be able to advise the president. He acted as a gatekeeper to Trump. He managed the time, very critical after Election Day. He was there to ensure a peaceful transition of power, which would have happened but for the incompetence at the January 6th day by the people who were supposed to secure the Capitol, or were either too dumb to do it appropriately or too complicit in allowing it to happen. One way or another, they failed. Mr. Meadows also exercised more specific duties in support of these general functions. He managed the White House staff, regularly coordinated meetings with the president, federal officials, other constituents. Phone number was plastered all over the wall in every bathroom in America, he said. Felt like everybody was calling. Meadows was on duty 24/7, traveled with the president, or sent a designee at all times. So even if the court were to conclude that some of the alleged conduct falls outside of the duties, removal would be justified if even one act falls within. And so here are the quick acts, right? They say, all right, Mr. Meadows under Act 5, they said, what did he do? I think they're defending this. They say Mr. Meadows considered this part with his role as chief of staff was consistent with his duties. So they're responding to each of the overt acts. They say in this one, Act 9, Mr. Meadows was not actually in this meeting. He was not involved at all. He was called down beforehand, and to notify visitors, they got positive COVID tests. The state presented no contrary evidence there. Act 19, Mr. Meadows did not ask for this memo, as Big Fanny says, but to the extent he was involved at all, it would have been within his role as chief of staff. Mr. Meadows visited Cobb County. He's allowed to do that. He was wanting to maintain awareness of matters that Trump would ask about. He called somebody called Francis Watson, all within the purview. So they're just saying all of these are within his job description. And there's a lot of acts there. Signed sincerely, George J. Terwilliger III. Shout out to George Terwilliger III. Good motion. Also submitted by John Moran and others on behalf of Mark Meadows. And this got dropped into the federal court. And so we'll see what the judge says about it. I mean, it seems pretty obvious to me. It's very clear. Fanny's trying to have it her way and feels like this is going to get removed without much more debate. But the Democrats are unhappy about that. They really do not want that happening. And so we've got Andrew Weissman, who's going to be complaining about what happens if there's no cameras in the courtroom. But what happens if this is not removed? There have been efforts to defund Big Fanny, and Brian Kemp in Georgia, who's somebody who's not a big Trump fan, has said, we're not doing that. Sorry. Here's what he says. I did want to take
just a few minutes to speak to some history that's trying to repeat itself over the last few days here in Georgia. Many of you will recall that in the final weeks of 2020, I clearly and repeatedly said that I would not be calling a special session of the General Assembly to overturn the 2020 election results because such an action would have been unconstitutional. It was that simple. Fast forward today, nearly 3 years later, memories are fading fast. There have been calls by one individual in the General Assembly and echoed outside of these walls by the former president for a special session that would ignore current Georgia law and directly interfere with the proceedings of a separate but equal branch of government. Up to this point, I have not seen any evidence that D.A. Willis's actions or lack thereof warrant action by the Prosecuting Attorney Oversight Commission.
Wow.
But that will ultimately be a decision that the commission will make. Regardless, in my mind, a special session of the General Assembly to end run around this law is not feasible and may ultimately prove to be unconstitutional. The bottom line is that in the state of Georgia, as long as I'm governor, we're going to follow the law and the Constitution, regardless of who it helps or harms politically. Over the last few years, some inside and outside of this building may have forgotten that, but I can assure you I have not. The oath I took with my hand on the Bible that's right behind me, in January of 23, is the same Bible that I took in my inauguration in 2019. And in Georgia, we will not be engaging in political theater that only inflames the emotions of the moment. We will do what is right. We will uphold our oath as public servant. And it's my belief that our state will be better off for it.
You know, I hope that he's right, but I don't think that he is. I think that we're going through this era right now where if you're not engaged in the political blood sport, that you're going to fall by the wayside. And so I think it's nice that, you know, we're going to be above board and big fanny's legitimate. And there's nothing that I need to say, even to mention that this is political at all. Doesn't even comment on it. Just says, we're just going to let it all go according to plan, even though large portions of even lefties are very concerned about this prosecution in particular. Her case might be about to be removed. It's going to be severed. She's got trial coming up on August 23rd, and she is asking that people's speedy trial rights be waived and their notice requirements be waived. I mean, there's like a bunch of insanity going on, but to just stand there kind of steadfastly and say, this is just normal business in America, and we're going to let the process go forward is one strategy. I think it's probably going to be a losing strategy, quite frankly. I think the other side, Trump is just the first person, right? They're already talking about in California, prosecuting and investigating and opening criminal probes into Texas for sending migrants over, and the list goes on, right? It's like open blood sport on the political stage. And quite frankly, I think that Kemp and guys like him, maybe that's part of the equation. They're a little concerned that maybe Big Fanny is going to come breathing down his neck, and nobody wants that to happen. So that's Brian Kemp. Not expecting much out of him or Georgia. We'll see if the federal courts remove it. But along the same line, here's Bill Barr, who for some reason is having a difficult time understanding how this is election interference, even though we've got 4 indictments that just dropped within the last 4.5 months. And all of them are going to climax right in the middle of election season, right in the middle of the highest point of attention when Americans are thinking about mailing in their ballots and making their donations, or criminal trials all taking place right there. And it's not election interference. Here's Bill.
Well, I think the governor is right. I mean, the basic principle in the criminal justice system is if a prominent person commits a crime and is seeking office, that doesn't give him immunity if there's enough time to have it resolved.
By the way, that's not what is being argued here. Just to pause on that. If you're running for office and you seek immunity, okay, that's not exactly what Trump is asking for. Actually, I don't think he's asking for that at all. Actually, I don't think anybody's asking for that at all. The only thing that we're asking for relative to the running is that he be allowed to speak freely. Not asking for immunity like you just can murder somebody. Running for president now. Be a great tactic for Hunter Biden. He should announce, for crying out loud. That's not what anybody's asking for. We're asking for, in that regard, that he be allowed to participate in the campaign and participate in the political process without being shackled and hampered by the criminal process. But that's not immunity. You can prosecute him, sure, but defer all of the trials until after the election. How about that? You can still prosecute him. Why does it have to happen before? Oh, well, because there's a reason for that. Because this is a lot less about justice than it is about scoring political points. So here's Bill.
Before the election, it should be resolved. The idea that, oh, okay, well, I'm sorry, we'll let you get run in the election and then after we'll address it. That's not a principle of the criminal. I mean, just think, some mayor charged with massive embezzlement, and he says, well, it's a year and a half to the election. Let's put that on hold. Will I run for re-election? It's silly. It's silly. Now, you can argue about whether he should have been charged and so forth.
Yes,
but the idea that this is interfering with the election is simply...
Yeah, it's simply wrong that the trial on January 6th is going to be scheduled one day before Super Tuesday, when most of the country goes to vote in the Republican primaries. Not election interference, all totally normal. And this is just people who are shifting their political opinions or the narrative that they're promoting at the current moment. So this is Andrew Weissman. We know he's a big fan on MSNBC. They love having him on here to talk about Trump stuff. And he is somebody who's been upset the federal case, that Trump's Georgia case, may be removed to the federal level. And he's saying this is all because Trump wants to avoid the cameras. And I'm thinking to myself, is that true? I don't know that is exactly true. I think Trump kind of really enjoys some of the camera. Here is Weissman. And
I'm wondering, is there something that emerges, like a larger thought that emerges for you about how Trump is handling this, or how the system is working? Because we're a little bit into it now. Do you have any larger perspectives as you think about this? Because I know you think about this all the time.
I do. I think that the biggest issue that I see looming really has to do with cameras in the courtroom.
Wow.
This is one where obviously
that's the biggest issue of all the issues, cameras in the courtroom. Not big fannies, panic button with the speedy trial request, none of this concern about the federal removal. It's about cameras.
for the first time in our history, we have a former president being charged. And it is correct for people to be concerned about making sure that this is not a show trial. We're not a banana republic. And I think the way...
Did you hear what he just said? He says, we want to make sure that people know this is not a show trial and that we're not a banana republic. This is a former prosecutor, by the way, and I'm sure he knows that Joe Biden is the person who is in charge of the Department of Justice, which is Merrick Garland. Merrick Garland is in charge of Jack Smith, who's leading these prosecutions. And there's a direct chain of news that connects Joe Biden to the entire prosecution. Banana Republic was launched. This is the banana. These prosecutions are the Banana Republic, Andrew.
To cut through that is to follow the model of the January 6th hearings, to follow the model, to date myself, of the Watergate hearings.
So he wants a fake show trial, just like the January 6th committee was. Remember, there was no adversarial proceedings in that at all. It was a bunch of Congress people, all with the same opinions, two so-called Republicans who are not even Republicans in Congress anymore because they got booted out and their districts were evaporated and they have no future in the Republican Party. So they were put on there on an illegally constituted committee. HR 503 said that it should have had 13 members on there, 8 of them Dems, 5 Republicans. Never happened. We had 9 total, 2 of whom were Republicans, so-called. So the whole thing was a scam, and there were liars on there. Cassidy Hutchinson, clavicle girl, said that the Secret Service helicopter had to drop the rope ladder and she was hanging off of the rope ladder with a .50 caliber to try to stop Trump, and she was barely successful. Full of lies. No opposing counsel, no cross-examination, nothing. But that's what these guys want. And he's a former prosecutor.
And so this is one reason I think the Georgia case is so significant. It's not so much that the Georgia case is one that whoever is the next president cannot pardon their way out of this case because it's a state case. Federal pardons don't apply there.
That too.
But I think the bigger import is, I think it's really important for the public, whichever way the trial goes, whether it's a conviction, a hung jury, or an acquittal, that everyone gets to see it, because we have such a huge problem now with disinformation and mistrust in the electorate.
Oh, man. So there, you see, my friends, they're starting to realize it, okay? They recognize that this mistrust, this disinformation, they know that we don't buy their garbage anymore, that this whole fake legitimacy doesn't exist. People are laughing at the mugshots. People are memeing a mugshot. For these people, this was like the most serious thing that they could ever do. This was rubbing Trump's face in the mud. And now we're all having fun with it, making t-shirts about it. How dare we not respect their system and their authority? They're serious people. And we don't think so. And that they can't stand that, man. They hate it so much. So instead, what they want to do, in my opinion, well, we'll see what he says and then we'll get there.
Sort of veering into your lane, Jen, but I think that is the real issue here, is making sure that the court of public opinion gets to see what's going on. So I think that's going to be really important for those watching all 4 of these cases to really keep their eye on Georgia and whether the case stays in the Georgia state court.
Yeah, because that's where their little propaganda base is. They're all extremely excited about it being televised because they think that they're going to win on that. I'm not so sure that they will, but that's the biggest concern, right? That's the number one thing that they're all really upset about. What if Trump takes this away? And my question is, if they are so assured of themselves that the evidence that comes out is going to be horrendous for Donald Trump, why are they so petrified from the Department of Justice of just letting us see everything? Why can't we see the actual documents, the evidence? The Department of Justice from Jack Smith cobbled together a protective order that's basically insane. Trump people can't talk about anything. So Weissman was saying that they wanted this to happen in the court of public opinion, but that's not what the DOJ says. DOJ says Trump should not even be able to tweet about this stuff. The other lefties say Trump should not even be able to tweet or X or Truth or anything because it is too dangerous to allow him to speak. This is why all of these things are filed under seal. This is why Judge Chutkan issued a protective order that means nobody can talk about anything. One side gets to leak to the New York Times and the Washington Post. Trump can't even keep copies of his notes. So here, out of the Florida case, look at all these sealed filings. rulings. If Trump is such a monster, just let us see the evidence. It's a historic case, blah, blah, blah. It's not about that, okay? They know Trump will crush the cameras. He is enjoying it heartily and merrily because he should. And this was something that I saw that he posted. Never surrender, holding up the mugshot, and he's absolutely right about that. And as this carries on, I think that the more exposure, the more we get to see, the more lame attempts from Big Fanny and Jack Smith and all these others, I think more people are going to recognize what a disgusting joke this is, and they're going to start to wake up. Trump certainly hopes so.
I hope that Republican district attorneys and attorney generals throughout the country are closely watching the tremendous weaponization of justice that is being utilized against me. There's never been anything like it. But you ought to watch, and frankly, it's an eye for an eye, or it's fight fire with fire. Woo. What they're doing to our country is amazing. So Republicans, I hope you're watching.
We're watching, Trump, and we're certainly hopeful that the Republicans wake up, because if they don't start indicting people themselves, well, then they all might end up in shackles. So that's Donald Trump filing a motion to sever. We're going to see what happens with the removal. We're going to continue to cover this case, my friends. I hope you subscribe and join us as we do, and we'll look forward to seeing you on the next one.